You can hear me? Good afternoon, everyone. I must thank Saurabh Bhai for making such an inspiring speech about the activities of WRC. I must congratulate you and the Institute for sure. But I'm saying thank you because that has taken a lot of my, my fear. Because a post-lunch session to keep members awake, a talk from you, Saurabh Bhai has already made people awake, and half of them have thought that it's better not to sleep because Saurabh Bhai is on stage. So thank you. So this is the topic which has been given to me, dry, dull, but at the same time, it is something which we have to, it's an unavoidable topic. And so let me, you have already had 2 sessions since morning, right, on DPDP. So instead of jumping straight on a slide, that what are the penalties, I will sort of refresh your minds, certain things, maybe a little bit of an overlap of what you all had discussed in the morning. But that is the reason behind it is, that it will help me to ask you questions if I need to, because you're already aware of the overview of the Act. Am I right? Thank you. So why this matters now? See, India is moving into the DPDP enforcement phase. The 13th November 2025, the rules were notified. And once the rules were notified, everyone were expecting that the Act which was enacted in August 2023 will be enforced and will be able to be easily implemented. But that was not going to be so. It is a staggered stage-wise implementation. On the 13th November 25, we had Rule 1, 2, and 17 to 21. These were the rules which were notified effective from November. Rule 4, which is consent manager, will be 13 November 2026, exactly 1 year after the rules are notified. And then 18 months from the date, that is from 13 November 2025, 18 months, is 13th May 2027, the remaining rules will be enforced, and that is when the real enforcement will start. It is a structured penalty regime because there are slabs for the penalties, and I will go through that in detail and the impact of them and how we need to mitigate and avoid those penalties. As we all know, data is a core business asset. We all have heard of data is the new oil and all, and I don't want to talk much of oil because we know what's going on globally just now, but data is the new oil and data is a core business asset. We are expanding digitally. So obviously when your businesses are expanding digitally, there is definitely going to be exposure from a digital angle. Definitely there's going to be a data breaches, definitely there's going to be data exposure, and therefore there is more importance to this subject. You are going to have a regulator, that is the DPDP board, and public scrutiny. Anything you do nowadays goes straight on social media. Reputation risk, as you know, because this is, once there's a data breach, okay, you may be, be able to pay the fines and the penalties, but it is a reputation risk, means it's coming. Would you like your organization or your client's organization name to come on the flashing on the first page of the Times of India or the Economic Times, saying that there's a data breach? You know the consequences. It's equal to your financial risk. Your customers will lose trust in you. If you're a hospital, your patients will lose trust in you. So reputation risk, in my view, is equal to financial risk. And this is now, the buck is going to stop at the board. So the board of directors, I'm not talking of the DPDP board, I'm talking of the board of directors. So the board is going to be more visible, and they are expected to be more visible in every organization to ensure that they are DPDP compliant. Enforcement, in my view, is going to be complaint driven. It's not that, it will be suo moto that the DPDP board will say that, I know there's I suspect some, data leak here, data breach there, let me take action. No. Somebody has to complain to the DPDP board, and then the DPDP board is going to start the enforcement action against you. And of course, there will be several cases, but the first few cases are going to be real precedents, and it will send the benchmark as to how this law is going to be actually enforced in practice. So what has changed? We had the Information Technology Act 2000, right? And we had the rules, the Information Technology Reasonable Security and Practices, and sensitive data protection, sensitive data information protection rules, 2011. Those rules are more security focused. There was no data privacy, data breach, And it was only for sensitive data. Sensitive data is like passwords, your financial data, health information related data, or data related to your your sexual orientation. All those were related only for that particular thing. And of course, there was a penalty over there, 5 lakhs penalty, and 3 months imprison, 3 years imprisonment, or both. But that was limited to only how your IT infrastructure is going to be protected. There's nothing about personal data and data breach and everything was not covered over there. Just to let you know, this Information Technology Act, which I'm talking about, is going to be amended, and there's a new law going to come called Digital India, but it's still in the pipeline. So if you compare it with DPDP is a rights-based. The rights, when I say rights, of course, you must have heard in the morning, the whole act has come from a fundamental right, the right to privacy. But otherwise, in the DPDP rules itself, there are rights. The data principal, whose data is the center, the focal point, the data principal has rights. And this whole DPDP Act is a rights-based framework. We'll talk about it in a little bit in detail later. So it's from IT compliance, the compliance to enterprise accountability. From a reactive, you don't react, just when something happens, breach happens, and then you react. That will not help. You'll have to have a complete life cycle governance right from day one till even the act is going to be enforced, and then later. And it's not merely technical. You must have heard there are many terms in this DPDP Act which are purely technical, but in my view, they are also legal and they are operational. They'll have to be embedded in your day-to-day systems. There's no option left. It's a mandatory law which it's going to be applicable. So what are the DPDP basics? Just to refresh, the data principal is the individual to whom the person, the data relates, and it is his information. You can directly correlate with him. Data fiduciary is one who determines the purpose and the means of the processing of the personal data. It is the data principal will give the data to the data fiduciary, of course, through a consent mechanism, and there are several other things which we will talk about. But sometimes the data fiduciary cannot do everything himself, so he gives it to a third party who's called a data processor who acts on behalf of the data fiduciary. Then there's a significant data fiduciary term which we will also cover it must have been covered in the morning, but I will also touch upon it because it's very important. There are separate obligations for a significant data fiduciary. And data fiduciary, let me tell you, in this DPDP Act, you might get things done from a data processor, but the principal agent relationship, the principal will be caught, not the agent. The same thing is in DPDP. The data fiduciary will be prosecuted, the liability will be, the penalty will had to be paid by the data fiduciary, not by the data processor. That does not mean that the data processor is left, chalo kuch bhi karo and chut jao. There is a contractual relationship between the data fiduciary and the data processor, and therefore all the indemnities, the compensation for breach, which the data DPDP board will levy on the data fiduciary, he will recover it through the contracts from the data processor. But there will be no direct penalty on the data processor from the DPDP board under this act. So the data processor, as I said, acts on instructions. The role clarity has to be very clear. Who is the data fiduciary? Who is the data processor? Sometimes there are joint data fiduciaries. Like, for example, you're booking tickets, you have Make My Trip, then you have the airline. Now, who's the data processor? Who's the data fiduciary? Sometimes this concept can be even a joint data fiduciary. Both of them can be held responsible if there's a breach. But if it is still given to a third party for processing, merely for processing, and nothing that is at the back end, then it can be even a data processor role. So the role clarity has to be very clear, and then accordingly you can structure your contracts. So these are the obligations of a data fiduciary. The first thing is only for a lawful purpose that you can collect that and store and process the data. There has to be a consent, and when I say consent, consent has to be specific, informed, unconditional, unambiguous, and it should be such that it creates an agreement between yes, I give you my consent. It has to be an affirmative consent, and this consent has to be, which is, you cannot take it just randomly for anything. It has to be for a specified purpose, and also not only for a specified purpose, it is to be limited to the data. Your data can't be collected, you can't take all your personal data, only that data which is necessary for that specified purpose, only that much data the data fiduciary can collect through the consent mechanism. The consent mechanism, as you know, it has to be in, you have got the option that it can be in all the languages which are in the 8th schedule of the Constitution, that all the 22 languages, and not just necessarily to be in English. And this has to be clear, concise language, and the consent will tell you very clearly that, this is the data of which I require for you if you want to avail my services, or if you want to use the platform of our organization. The data fiduciary will very clearly say this all is required, and I require a consent for this person, not just a tick box like we nowadays you see. You tick, and then that means consent is given. That kind of thing will not work anymore. There have to be reasonable security safeguards. That's a very important thing, because they have to ensure that there is, and this is under Rule 6, encryption, obfuscation of data, masking of data. You have to have appropriate logs to check verifying whether the processes are correct or not. You have to even have technical and operational measures, contracts between the data fiduciary and the data contract. These are all reasonable security safeguards laid down in Rule 6, which are the obligation of a data fiduciary. Storage limitation is this, what I said, that take data only for what is required to meet the purpose. Data minimization is the principle here. And accountability, of course, as I said, it's the data fiduciary who's going to be accountable, directly accountable, not the data processor. So what are the rights of the data principle? Right to access the data at any time. If there's some correction needed, sometimes there's a typo, or there's some change of some data address, something is there, you need to correct it, he has to have a right to correct it. A right to erase his data. He does not want his data to be there. The service is over, or sometimes the service is not even complete, but he wants to erase it. Of course, then the responsibility is of that data principal. You can't hold the data fiduciary responsible for not completing that process, because this guy wants his data to be erased. There are certain, if it's a hospital or it's a patient, there are certain things where you have to still keep it beyond the retention period. Normally 1 year is okay, but not for medical. If it's a clinical establishment, it can be even for a longer period. If it's some other e-platform, it will be for 3 years. So those data requirements of different sectoral laws will have to be complied with. But otherwise, he has a right to ask for erasing his data. Right to grievance. Even in that consent, when I said you give a notice to ask for consent, in that notice itself, you have to say what is the grievance mechanism available for that data principal, that where he can go and complain to. Is there a data protection officer available, or is there any other person available, or is there some email ID where he can, a link, of where he can click on that link and he can go to the site and say, yes, here is my grievance. And of course, when you have a grievance, there is a separate thing for when the grievances should be fulfilled and should be redressed. But here I'm talking of rights of the data principal. He has a right to nominate, like you have in the banks, same way here he has a right to nominate that whoever, in case he is incapacitated or he is no more on this earth, there is somebody else who can access the services or the uses of the platform. Transparency is absolutely a right. The data principal has the full right that for the data fiduciary to be fully transparent, and all responses he expects should be time bound. So what is a significant data fiduciary? Anyone can tell me? I think, okay, yeah. Sorry? Can you talk a little louder so that everyone can hear you? They are not significant data fiduciary. The reason being that today in the Act, nobody is yet a significant data fiduciary. The reason being, correct. The reason being that the government is still not notified. But then how will the government notify? It is based on certain relevant factors. And those relevant factors are, the volume and sensitivity of the personal data, the risk to the data protection, the data principal's rights, whether there's a risk to the security of the country, whether there's a potential impact on the sovereignty of the country, whether there's a risk to electoral democracy. These kind of entities who may have these kind of things, only those. So to tell you in simple language, you can take it for sure, there are two sectors which will definitely come under significant data fiduciary. It's a class of data fiduciaries or data fiduciary, both will come under this definition. One is the financial sector and the second is the health sector. These both have high volumes and sensitive information for sure. So you can expect that the government will definitely have these two as significant data fiduciaries. Yes, I mean, they can, because it depends on, especially children's education, but how it is sensitive enough that over there is more for volume of data. But when you say sensitivity of data, education may not be considered. It is data privacy and data will be there. But when it is significant data fiduciary, there are additional obligations. And that is, the obligations are such like you have to have a data protection impact assessment. The complete process has to be assessed. You have to see whether there are processes for the rights of the data principal are respected. Is there a consent mechanism properly in place? Is there any breaches? What are the breach response procedures in place? Everything has to be done in a DPIA, that is the Data Protection Impact Assessment. Second thing, you have to appoint a DPO. Data Protection Officer is a good to have. It's not, in my view, if you ask me, even if you're not a significant data fiduciary, you should have a DPO, because the DPO is the center point. He's not only for the outside world, the data principal will be like a one point touch point or contact point, but he has to also see whether the rules and everything are complied with. If there's any notice to be given, if there's anything, he's the one who has to do everything. And DPO need not be physical. You can even have a virtual DPO. What I mean by virtual DPO is that we even do it for organizations that, there are certain companies who have headcount restrictions, right? And when you have headcount restrictions, you don't want one more DPO. I will ask my CISO, that is the Information Security Officer, or I'll ask my IT person to do it. Or I'll ask my legal guy to do it because he knows DPDP law. Let him be the DPO. Let the compliance guy be the DPO. No, there can be no conflict of interest with any of these roles. It has to be an independent role and directly reporting either to the board or equivalent. So your boss of the DPO must be someone who has got direct access to the board. He might be a director, a whole-time director who's part of the board. That is the independence of the data and the importance of a data protection officer. And data protection officer is someone who has to, his name everywhere is with the website and everywhere that, he's the one whom you can contact. Sorry? No. If some companies are having it, 13th May 2027, they'll have to stop. They will have to appoint somebody else. I know there are cases where the CISO is there, legal guy is also a DPO, there is also a compliance person is a DPO. It will have to be an independent, no conflict of interest position and directly reporting to the board or an equivalent. The second is appoint an independent data auditor. Now I'm telling you this word audit and auditor during my presentation. Someone can count. You'll find that it's a good business for CAs. There is a lot of auditor. These things are happening in this DPDP Act, and this is not audit of figures. This is audit of seeing that the entire processes under the DPDP law are complied with or not. And both this data protection impact assessment report and this independent data auditor report have to be filed with the data protection board. So then there's the significant data fiduciary has to ensure that there are due diligence of all the technical measures. And even as we all were talking of AI, even the algorithmic software has to be, the clear due diligence has to be done on that so that there's no risk to the rights of a data principal. Ensure data localization. Does anyone know what this term means? Correct. The data has to be localized only in India. And because there are rules very clearly that cross-border data transfers are not going to be allowed. It's not going to be absolutely not allowed, no, but there are certain countries will come in a negative list. And this list will be notified by the central government after a committee decides which countries should be there in that list. So when you are having a significant data fiduciary, all the more you have to be careful that you're not falling. Everyone has to be careful, but they have to be even more careful that there's no cross-border transfers which are not allowed. They have to ensure that there's enhanced data governance and continuous monitoring. It's not a one-time job. So DPDP rules, they are just converting the principles into enforcement action. Operational how the act is going to be operationalized is only through these rules. There are breach notification timelines. The notification of a breach, once a breach takes place, I'm going to have some slides on breach, so I'm not going to take time now on that. The consent notice structure, whether you're going to have it in-house or whether you're going to have it through a consent manager. You can have a consent manager, a third party. What is a consent manager? He's a person. Person means not an individual. Person means it can be a company, body corporate, everything is a person. So that person can be your consent manager who then does the job of taking all the consents, all those formalities of withdrawing consent, consent, access to the consent, everything relating to consent is done by this consent manager. And of course, to have a consent manager, you have to register them, and that is the one which is in Rule 4, which is from 13 November 2026. The consent managers will have to get registered with the DPDP board, and the consent managers will then, there's a minimum net worth of 2 crores which they have to have in order to be a consent manager, and then they have to have the relevant specific technical capabilities to be, get, of course, if you do not, and if there are complaints, there is a process that you are given a show cause notice, and then you can be even removed as a consent manager. There are many organizations today, these IT software companies and all, they are going to do consent manager as a vertical. So what is data breach? How it actually unfolds is this. There's a detection of anomaly in there. Somebody says, kuch to gadbad hai. It starts from there. Then, yes, the IT guys and the internal, they confirm, yes, there is a breach. Then internally they escalate. They tell, अरे boss को बोलेगा क्या? इसको अरे data breach तो हो गया है. अभी क्या करने का? So that internal escalation starts. There's lack of clarity because they don't exactly know whether it's how did it happen? Is it because of somebody within the organization? It is somebody, an external thing? Is it a ransomware? Is it hacking? Generally, there's a lack of clarity in this. There's no defined ownership. Everyone at that time will raise a, maine nahi kiya, tera responsibility, mera nahi tha. That happens. This I'm telling you will happen once the Act enforces. Why I'm telling you is from global experience that we are seeing how the GDP and GDPR and everything happened. These things are from experience that we are telling you. There's a delay therefore in decision making because you have to take that decision that yes, and now let's go into the next steps. It's a situation of chaos within the organization for sure. Most organizations today are unprepared. They don't have a data breach response plan. There's no clear incident owner as to who is the owner if there's a default. In such a case, the IT team, the legal team, the business teams are all misaligned. Nobody is going to be saying this, that it is done by us, or let us together come and take a corrective action, or the next steps to be taken once a breach is done, breach is identified. As I said, it is very common to try to delay escalation. The data inventory itself, you don't have it in the first place. When a breach takes place, you can imagine the data inventory is easily not available. And therefore, the first 6 to 12 hours, once a data breach is you understand there's a breach, the first 6 to 12 hours are very critical. So enterprises, actually what we do is that there's an initial assessment and gap analysis, there's a data mapping and inventory, there's a data protection impact assessment, there's a policy and procedure development, implementation of security measures are required, data subjects right management is required, training and awareness programs are required and absolutely essential. There has to be a data breach response plan, as I mentioned, regular audits and compliance reviews, and appointment of a DPO. All these services we provide these kind of services. So what are the failure categories? What kind of things can be considered as a failure in this act? Security safeguard failure, absence of a rights response workflow. If you do not have a rights response, because the right to withdraw has to be, the process has to be so easy as you had the right to, when the consent was taken, it was an easy process. So same thing when you want to withdraw your consent, the process has to be equally easy. Consent violations can be a failure, that if a consent is not given and the data is processed, or it is processed for the purpose which is not defined, or it is processed for some personal data which is not as per the purpose. Your third-party agents are vendors, and if any failure on the vendor will be definitely considered as a failure for you. Governance lapses for sure. Breach reporting failure, which is something which I'm going to go very deep into. I just talked about what the breach scenario is, but breach reporting failure is definitely going to be a major violation. Monitoring failure, if the DPDP board finds that you're not able to monitor what's happening in the data framework, then it's definitely going to lead to a failure. And how failures happen? There could be cloud misconfiguration. There are certain cloud servers, and they are like, they've got several tenants, sitting over there, not just one-to-one. They do service for many companies or organizations. So if there is any misconfiguration that iska data udhar or this company's slight thing happens, you can definitely have a big major data breach and data privacy leakage problem. API exposure, the application programming interface which you have in apps, If there's a problem over there itself, you can have a failure in your data configuration. Weak access control. Anybody can access if you don't have strong passwords, if you don't have only need to know basis. Certain time, anybody accesses, the data in the organization. But are you anything connected with you? Even in hospitals, I'll tell you, there are certain things. In one, I don't want to take a name, there's a healthcare center where the head, very senior person, known person, says everything should come to me because I am the head. Sorry, do you need to know that data? No. We said 13 May 27 onward, you definitely get the highest number of the level of fine because you need not know that data. Please stay away from it. If there are no audit logs, that means it's a sure shot failure because then you don't know who accessed the data, when, for what, when was it withdrawn, when was it given. Everything, if it's not logged properly, there's no audit trail, it's a failure. Insider threat, there are certain people who are disgruntled, right? There are people there who can leak your data, and these insider threats can lead to a failure. Backup exposure, you have a backup, but sometimes that backup is not, if there's a data breach and there's a problem with your main server, there's no recovery process in time. Or you have a backup, but that backup server is outside the country, and you are here in that negative list, that backup over there will be considered as a failure. Phishing attacks, need not mention, that is definitely a reason for failure. So this is basically a chain reaction. What the regulator is seeing is not data breach ho gaya means chalo, direct fine. No, he's going to see the entire life cycle of your data governance. One breach could lead to multiple violations. I'll explain to you what I mean by that. Here it's security plus reporting plus rights. All these things will see. He'll see whether the data, your technical measures were there to keep it secure. He will see whether you're reporting things. If you're a significant data fighter, did you report annually in time the DPI assessment report and the audit report? Were there internal audits in place? Everything will be seen. Plus the rights of the data principal, were they respected? Were they observed? Were they fulfilled? And the increased penalty exposure is definitely going to be there when there are failures, but it is not going to be, if you have mitigation measures in place, you're not going to be right directly at that 250 crores. Escalation impact, because it's a chain reaction. Once the guy who detects the breach, he informs his IT guy, the IT guy informs the CISO guy will inform the board, the director to the board. So at the board level, this will be definitely going, and then it has to be escalated to the data protection board. So this entire escalation chain will start. There are obviously legal consequences. The law firms will say, yes, we've got something very much in hand. Please, I'll tell you that you can't take an injunction. You can't go to a civil court and take injunction. If there is something, an action against you, you can't go running to the civil court and say, the injunction, please stop the data protection board from taking action against me. That is not allowed under this DPDP Act. So the data protection board itself will start your entire, the process of seeing whether, what your breach was, how it is. And there is, of course, an appeal mechanism is also there, because the data protection boards, you can appeal those decisions, not in the civil court, but in the Telecom Disputes and Settlement Appellate Tribunal, which is the same one which under TRAI, the Telecom Regulatory Authority Act. There's an appellate tribunal there. There's the same appellate tribunal which is sitting in this DPDP Act. So what is the penalty philosophy? Like always, we know why are penalties? Because they are triggered mainly by lack of preparedness, right? Not merely the breach. The breach is a consequence. The lack of preparedness is the starting point. Financial deterrence. The penalties are specifically on the higher scale because to deter you from next time again, having a breach in your organization. It's a behavior correction, right? Certain organizations say, chalo na kuch dikhta hai na kya hoega. Let some 1-2 cases happen, then we will see. So it's a niti. It's a question of niti more than of changing the behavior of the person. Accountability enforcement, you make somebody accountable, that's the data fiduciary. Let the data fiduciary then hold the data processor responsible. But first have the data fiduciary accountable. The penalties are all risk-based. There is no imprisonment under the DPDP law. In fact, most of our laws today also are getting decriminalized. So in the DPDP law, there are no penalties as such. There is no imprisonment as such. There are only penalties which we have to be paid for once they are levied. Of course, needless to say, it's a high monetary exposure, and reputational impact and loss of trust are a definite, once penalties are levied, as I said earlier also, it will definitely be an impact on your reputation and loss of trust of your customers. If it's in the healthcare sector, of your patients, if you're a bank, nobody will again come back to you saying that you'll switch your account to somewhere else. यहाँ तो मेरा data leak होते हैं, इनको penalty हो गया. These consequences are always there. So what are the DPDP penalties? First one is the breach in observing the obligations of a data fiduciary to implement those reasonable security safeguards, those ones which I said, where if you don't have encryption of data, you don't have data logging, you don't have obfuscation of data, you don't have contracts in place between the fiduciary and the data processor, you don't have technical and legal measures in place. All those are the reasonable security measures under Rule 6. And if you do not observe them, the fine can go up to 250 crores. And mind you, friends, it is for single breach. That means because of the same reason, if there are 2 breaches, the fine is twice. So it's 1 breach and the fine is up to 250 crores. Now I talked of data breach, right? And then I talked of that you have to notify to the data principal. Now data protection board. Now the data principal whose data is affected, because the breach he is affected, you will have to notify to him or her as well as to the data protection board. And failure to do so, the penalty is up to 200 crores. Non-observance regarding children's data, for children's data, there are certain obligations that you can't, expose them to targeted advertising. You cannot have certain data of theirs which you can use anywhere else. Nothing should be harmful to them. Those specific things regarding children's data. And over there also, who's the data principal? The data principal is the verifiable parent, or who's or the lawful guardian if there is no one over there, who will be the data principal in that case. And non-observance by the data fiduciary for obligations regarding children's data is again up to 200 crores. Breach, the significant data fiduciary, as I said, had additional obligations. Which were they? DPIA, data protection impact assessment, appoint a DPO, right? Have reasonable security measures in place, see that your data is localized. All those additional obligations which are there, have regular audits, all those things, if you do not comply, another 150 crores. Breach of there's sometimes in the process of DPBI, there's some voluntary undertakings they're given. So to the extent of the undertaking, whatever is mentioned in that, under section 28, it's not quantified as yet, but the breach will have that applicable penalty. And breach of any other provision of the DPDP Act is another 50 crores. Now data principal, if he himself is not transparent, if he gives wrong information, or if he tries to, he impersonates somebody else, those kinds of things are on the data principal is a fine of 10,000. Now I had said that, there's one breach and multiple penalties. You can see it from here. The first one you see, data fiduciary, the reasonable security safeguards are not there, 250 crores. But what after that he fails to notify to the data principal or the board, another 200 crores. What if he's an SDF? That means, he has got those additional obligations. He doesn't do them, another 150 crores. I'm talking of the highest, it is up to. But still you can imagine that, for one breach you can have these are multiple violations and multiple violations and multiple penalties. So this is the penalty structure, up to 250 crores per instance, multiple violations per incident. Independent assessment will have to be done when there's a data breach. There's no fixed formula. There's no fixed formula as to up to 250 means should I do it 100 crores or should I do 250 crores? There's no fixed formula. Although there are certain factors which have been given in the DPDP Act that looking at what is the nature of the gravity of the breach, see the size of the company. Is it such that uska turnover is 100 crores and 250 crores ka fine, or his business will be closed tomorrow? So those factors will be taken into consideration. They will also see whether it's a recurrent, the guy is always defaulting, or is a first time default. Does he have systems in place, but still there's a breach? All those factors will be taken into consideration when deciding how much should be the penalty. But believe me, it will not be 5 lakhs and 10 lakhs because the upper ceiling is 250 crores. So the penalty will definitely run in crores for sure, even if it is on the lesser side. So repeat offenses will definitely be penalized higher, and your entire process before the Data Protection Board will be influenced by your documentation. You will have to show to the data protection board that, see, these are the measures I did take in place, these are the audit logs I have, these are the processes in place, these are the policies which I have a data process consent policy, retention policy, data breach response policy, everything I've got in place. Still there is a breach. The data protection board will levy a penalty, but may not be very high. The early cases, as I said, will set a precedent, because only ek do case aa jayega in per industry. This is going to have ripple effects in the for the other companies within that industry. So what is the risk framework? First, you have to identify your risk. You assess the impact of your risk, right? Implement controls, the data access controls, the controls for even within the organization, for otherwise for, seeing that there's no breach. Monitor continuously. Review periodically, because you have these audits. Review them periodically, because one is on a yearly basis. You can even have internal audits. You can specify the period, once in 3 months, once in 6 months, depending on how the volume and sensitive date of the data which you have in your organization. This will only improve your risk maturity. And this is not a one-time exercise. That 13th May 2027, so you start your preparedness today, and then once you are thinking that you're prepared, there's a one-time exercise, ho gaya, chalo, I'm DPDP compliant. No. It's a regular exercise, because breach can happen anytime, any day. This is based on global experience that we are telling you. Even today, breaches are happening, but what I'm trying to tell you is that even after your entire preparedness, don't think that you can sit, ho gaya, mere ko, this organization gave me one certificate. By the way, there's no certification under the DPDP Act that you are DPDP compliant, ho gaya. These only for good to feel that somebody gave me a certificate, seeing on certain things I've complied with, but that certificate ho gaya, that means you sat in your cozy cabin thinking that my organization is DPDP compliant. You are it's going to be a sure failure. So this is a continuous cycle, and you need ownership. Somebody has to own a breach. Ultimately, somebody has to own this entire process. Tools can help, but you need, because you have AI tools, you have other tools, but you need human intervention to see that those tools are really functioning to the maximum capacity it was envisaged for. To see that they are really helping you in data compliance or the DPDP compliance, or the tool itself is creating more problems for you. It requires cross-functional effort. As I said, these departments, they work in silos. You have an IT department, legal department, then there's a CISO sitting on top of that IT guy. So that means there's a cyber security and one more person is there. Business is separate. If these are going to, because data is sitting everywhere, right? Personal data, and you don't know where it is and how it is. So when a data breach takes place, if there's no cross-functional effort, you can imagine what will happen. Sure failure again. And alignment with the auditors is very important. I mean, there are recommendations that even audit committee should be responsible for data privacy. You should keep up. There are certain discussions that you should have a separate data privacy committee within the organization. But whatever it may be, you have to have internal audits. If you have a significant data fiduciary, you'll have to have an external auditor. All these audits, there have to be alignment with the management on a regular basis. So what are the risks of DPDP leading to violation? The first one is unclear data inventory and mapping. You don't know only where the data is sitting in your organization, what is the data flow, where is the data. If you don't know that, you can know that there is a big DPDP risk for you. Invalid or poorly designed consent mechanism. If you do not have the consent mechanism in place, if you don't have it, take the services of a consent manager who will get registered under Rule 4 from 13 November 26 onwards. But take their services, but have a proper consent mechanism, because if the data is processed without consent and without for the right purpose, and for the data which is not required for the purpose, if that is stored, it's a major risk for the organization. Because it has, as I said, it has to be free, specific, informed, unconditional, unambiguous. These things are very, they look theoretically one sentence here, but they are actually each minor thing which can blow up into, a big DPDP risk. Inability to handle data principal rights. If you do not have a rights workflow in the organization, then there are rights. Suddenly there'll be a request for nomination. Suddenly there'll be a request for withdrawal of consent. Suddenly there'll be a request for, I want to transfer my data from this hospital. My patient is now into some other hospital. So my data is I need over there. So data portability request. All these requests are going to be too much for an organization if you don't have a proper mechanism to handle these rights. So if there are any operational gaps to any of these data, people suddenly say, I want the data to be erased, and you don't know the data retention rules or the timelines for that particular sector, and you do erase that data by mistake, completely. Again, you are in a soup. Weak vendor-processor contracts is a big major risk, because your data is processed by the data processor, who is a third party. And if he commits or his systems commit a breach, you are going to be held up, right? You means the data fiduciary is going to be held up. So if the contractual terms have to be such that you can hold him responsible, you can hold his neck. But if you have a simple, give him a normal work order, the different things, that if there is something, I will hold you responsible, simple language will not do. You will have to have proper terms to the really under Data Privacy, Data Protection Act, you can really haul him. So the vendor processor contracts, if they are weak, is definitely a risk. Because there are cloud agencies, you have to know that, who is it. Sometimes there are SaaS platforms are there. If they are not having DPDP compliant contractual safeguards, then you have a problem. You have to have data retention policies and data deletion frameworks properly in place. And if you do not have it, it is a major DPDP risk, and which will lead to a violation, which will lead to a penalty. Because you have to have automation definitely in this, but even in automation, see that the automation tool really works or not. Keep testing it. Inadequate breach detection and reporting readiness. If you do not have a system which will detect the breach, normally automated systems detect the breach, but after detection, you do not know the next steps, and you are not ready for reporting. As I saw, one is 250 crores of fine, the other is 200. Both will be applicable. If you are not able to detect a breach, and that is because there's a reasonable security safeguards are not there. And secondly, because you did not report in time to the data principal as well as to the board, again there's a fine. Shadow IT and uncontrolled data sharing. In many organizations, there are people who use WhatsApp and this, and then they don't know that even there are certain AI tools connected with that, and by which your data is getting leaked. And you do not know that. Even in if you see in healthcare, I'm just giving a simple example of healthcare, because or even in the bank, you will find that let me know what is my balance. Of course, today you can go in the app, this, that, and all. But if you take an example of a hospital, one doctor sends the data to another doctor. Now that other doctor is not the treating doctor. Still, he has on WhatsApp that access of the data. Why? Because he wants to study something new, But that is a major violation under the DPDP Act. The hospital will definitely fine 250 crores, the highest cap for sure. Misalignment, as I said again, between IT security and legal compliance. Cyber security measures are there in the organization. They are strong cyber security measures, but they do not know how they have to be compliant with the DPDP timelines, the DPDP processes. If that alignment is not there between legal and the cyber security team, it's going to be a risk. Because you have to have data minimization. You are taking data which is not required also. It is sitting on your servers. You will be fined. Lack of accountability. If there's no clear DPO-like role, when I say DPO-like role means DPO is for SDFs, significant data fiduciary. But if you are not, have a DPO-like role. Like to your example which you said, CISO. If a CISO, if he is not a significant data fiduciary, you can give him that responsibility. That, okay, you take this responsibility. But if he is a significant data fiduciary, the CISO and DPO have to be two different persons. CTO. CDO means you're calling him what? Chief what? D is for what? So what is his role? Correct. And what is the role of now supposing he's having control of the full data, right? And there's a data breach. Do you think that he will take that because it is his neck, right? He will see that kaisa main isme se bahar niklunga, ke kaisa karega. He will try to cover it up. The data protection officer's job is to see breach ho gaya, I have to report, nahi to mera organization ko 200 crores additional fine hai. That is the reason why this data protection officer's role is independent of a data. You call him a data, as you call chief data officer, you call him a CISO, you call him anything. There's no conflict of interest has to be there for this very reason, so that the breach is reported in time. The affected individual is reported in time. And when I say affected individual, let me tell you, I have been a victim, not so much of a financial exposure over there, but I'll give you a live example of what has happened, and then you'll understand how data principal rights are respected, and in other countries, and even in India also, of course, under the DPDP law, that if there is a data breach, if you do not notify the affected data principal, there is an implication, not just for the data principal, because he needs to know that his data has got access leaked. Other suddenly he'll wonder, मेरा data isko diya, idhar kaise aa gaya? That is because this fellow has breached it. There's some breach taken place. There's some cybersecurity problem over there. So you have to first inform the data principal that, boss, your data has been breached. We are taking some measures to rectify it, to mitigate it, but you need to notify to him. So as I said, if responsibility is fragmented across legal, IT, and business teams, then there's no single accountable owner. You have a problem on hand. Overconfidence. We have seen many clients, hum log ISO 27001 hai yaar, GDPR hai we are doing. What are you telling? We are not DPDP compliant. No, you are not. The ball game is different. The requirements are different. Many of them may be similar, but there are certain things which are different. You have to be DPDP ready. It's a different exercise altogether. It's like playing T20, the rules are different, and playing a test match, the rules are different, right? So the organization, they assume existing frameworks are sufficient, but they miss the India-specific requirements under the DPDP Act and rules. Now, how is the enforcement mechanism? If there's a data breach or there's a complaint, it triggers action, right? Then the Data Protection Board will start the inquiry. A notice will be issued to the organization that, boss, we've received a complaint that there has been a data breach in your organization. Please tell us what steps you took, what is the details. We received a report from, either it's a complaint or it's a data breach report given by the organization itself. You'll get an opportunity to respond, because under the principles of natural justice, the organization will get an opportunity to respond if there's a complaint or if there's a data breach as to what happened, why. It's not straight that a penalty will be levied on you. Your entire evidence will be evaluated, all your documentation, all your policies, whether the process right from the time the consent was taken, the access controls you have, do you have audit logs, everything will be seen by the Data Protection Board before deciding how much penalty should I levy on this organization. Then, as I said, then the decision is taken as to how much should be the penalty. The appeal mechanism is there, as I said. It is the same, the Telecom Disputes and Settlement and Appellate Tribunal. This is the TDSAT, as we say it. This is the appellate tribunal, where is an appeal mechanism. You can always appeal against the decisions of, and then straight Supreme Court. But there's no other civil court or high court which you can intervene and say, somebody can run, nowadays kuch bhi ho gaya, go run, take an injunction to stop my, the proceedings which are going on. This will not help here. So let me start with real world examples, because, it'll be a little interesting for you to see how the jurisprudence has evolved in other countries. Because in India, if you tell me, give me an example, you're talking all these things, but in India, kahan aisa hua hai? Nahi hua hai, because 13th May 27, it is going to be enforced, right? But let me give you a flavor of real world examples of what has happened in other jurisdictions to give you a little bit of, the seriousness of this data privacy. British Airways in 2018 were the authority over there issued a penalty in 2020. So what happened? The customer booking and payment data was scraped after users were redirected to a fraudulent site, and about 380 to 500,000 travelers' data was affected. So remember, this is customer booking, and then the payment data was redirected to another site, and that was a fraudulent site. The root cause was simple. Pure security arrangements were there. The third-party partner account was compromised, and there were missing controls. There was no MFA. MFA is, we call it multi-factor authorization. You must have read recently that RBI is saying that there will be two-step authorizations, right? Those are those multi-factor authorizations which are required to ensure that this did not happen here, and therefore the admin credentials there was absence of those credentials which were not segregated properly. So how it could have been avoided? You should have had strict third-party access controls. Multi-factor authorization should have been there, and regular pen tests should have been there. What are pen tests? Pen tests are those simulations, proactive simulations done if there is a cybersecurity threat. Actual simulation is done so that if there's a it's like a mock drill kind of a thing, where there is a cybersecurity attack is done on your system, and then you see which are the gaps which you find, which are the data vulnerabilities, which are the patches, and then you improve on those patches, or you improve the systems before the actual attackers take place. These regular pen tests were not done. This could have been done, and if you had done monitoring, then they could have monitored for web skimming. From a DPDP perspective, what is the lesson? You need mandatory vendor processor due diligence. Here it was a third-party site. They should have done due diligence of that vendor processor. They should have had an incident response playbooks in place. So this happens, then immediately what to do. And the apps which are handling sensitive data must enforce MFA, and the vendor audit should be upfront. Let's take another example. This is the Marriott International breach which was discovered in 2018. Here the Starwood systems are compromised back in 2014. Now Starwood was acquired. So there was a merger amalgamation kind of a thing which happened, and therefore Starwood's legacy data and the legacy problems came into the Marriott system. The attackers accessed the Starwood reservation system, passport numbers, payment cards, and 339 million people worldwide were affected. The root cause was, again, poor acquisition due diligence. When I say acquisition, means the acquisition at the time of acquiring the entity. The poor due diligence at that time. Nowadays, we all do M&A transactions, right? Now we have to do diligence even from a data privacy angle. That are there, controls in that organization which are weak from a DPDP angle, because otherwise you're going to inherit them. Or have in your agreements very clearly those, that if that is there, then tomorrow we will hold you back responsible. There was insufficient encryption of the data, and there was no inventory of the personal data in this case. It could have been avoided through due diligence when at the time of the M&A process, the data inventory mapping should have been done post-acquisition. Post-acquisition, they should have seen where the data is now lying, because priorly it was just Marriott. Now it is Starwood and Marriott. Then the tokenization and encryption of sensitive fields should have been done. Indian entities from a DPD perspective should insist for data protection impact assessment at the time of acquisition. Have that, insist on the complete data protection impact assessment when you're doing your M&A transaction. You maintain up-to-date data inventories right till the date now at the time of the takeover, or the time of the merger, or the time of the amalgamation. Do the complete up-to-date data inventory, and you bake the contractual warranties into the transfer asset purchase agreements itself, so that even if there is something later on comes to know, you can go back to the company whose assets you had acquired, or the company which you had acquired. Google, this is a French, this was Google LLC, but this was a French decision in 2019. 50 million euros was the fine, because they found that there was a lack of clear portable information, valid consent for ad personalization. You have these ads sometimes, so there was no transparency or consent, and it was not just a classical hack. There were complex, here the root cause was there were complex user experience that didn't deliver informed consent. The consent process itself was so complicated. Under the DPDP Act, you need a simple process which is there so that the person can understand how to give the consent, how to withdraw the consent, how to give other notices to them. Very simple. Here the user interface itself, the user experience itself was very complex. As I said, you should have the notice flow should have been simple. You should have when they had advertising choices, right? They should have separated the core choice from the advertising choice. Given the option for a particular data principal who wants to enter that, I don't want any advertisement, my data to go to those companies and things. That option should have been given to them. And lesson from DPDP perspective is that you have to prioritize in clear local language notice, auditable consent records. The consent record should be auditable, especially for patient apps and for research registries. This is even very more pertinent. This is the H&M Hamburg decision in 2020, where there were detailed personal internal notes about employees were collected, and they were accessible to many managers within the organization, which means there was unlawful excessive monitoring of the employees. A manager who need not know anything about the employee was having data about an employee. So tomorrow if he comes to my department, I know iska kya hai. So the root cause was there was internal surveillance without lawful basis or need to know basis. You need not know, you still were having access to the data. It could have been avoided by applying purpose limitation, as I said, minimize the data collection in the organization. Role-based access control. Those roles who do not need access, don't have that access to them. And have HR-specific data protection impact assessments. In India, employers must avoid over-collection of staff, health, disciplinary data, and document lawful basis and retention limits. Don't collect data which is not required. For your employment purpose, whatever is required, collect only that minimum data. Tomorrow you don't have that additional headache of somebody else uses it, misuses it. At the very outset, don't collect what is not required. Amazon Europe Luxembourg decision, it was a record fine of Europe of 746 million euros. This is contested, but what happened was that the regulators found advertising and cookie processing lacking. There was no valid consent was there in this. There was no justification also. The root cause was heavy ad tracking and inadequate consent gating. When consent gating means, at the very access, there was no consent mechanism in place. The gatekeeper itself was faulty for all the European Union users. It could have been easily avoided by implementing prior granular consent for tracking, design privacy-first ad architectures within your platform. Separate the advertising, as I said in the other example also, from your essential services. Indian digital platforms must avoid opaque profiling. Don't profile and have a profile of your customer or thing which is not required. Don't do that. Take consent for analytics. If your data you're taking and it is going to be used for AI or it is going to be used for research, take consent. Just because you're going to anonymize it does not mean that you can do it. You need to take consent because your primary purpose was for that particular reason which was given in the notice when you took consent. You cannot later say that I want to use it for doing some research or I want to use it for some analytics on my AI tool. You need consent at the very outset. Can I just take a little bit of water? Thank you. Okay. Let's go to the next one. This was Ireland, WhatsApp Ireland. This is a DPC's Data Protection Commission decision in 2021. The fine was 225 million euros. What happened? The regulators found shortcomings in transparency about data sharing between WhatsApp and other meta companies and how the user data is handled. Root cause, insufficient clear notices and explanations for cross-service sharing. This, if anyone knows, was also happening in India, but the courts in India pulled up Meta and said that you cannot do this. You cannot use your data from within because it's a one organization, something from Facebook to WhatsApp, WhatsApp to Instagram was done. They had said that if you want, take it or leave it. The court said, no, you cannot do that. Option of opting out is there with the data principle. So Meta said, yes, we will do it. They withdrew their appeal and they modified it. So similar thing had happened in Ireland. How it could have been avoided with clear, concise privacy notices, explicit prominent disclosures on cross-service processing. When cross-servicing means from within the organization, from one platform to the other platform, Meta to Facebook, Facebook to Instagram, I'm referring to those cross-service processing. And opt-out should be there wherever possible. So from DPDP perspective, document the cross-service data flows. Sometimes you have hospital portals and you have telemedicine plugins, right? So that you're taking telemedicine and then you're giving to somebody else in the hospital who doesn't require it. If you're giving it, give it, but take consent at the outset. Airline plus online travel aggregator, like Make My Trip, there's a cross transfer here. But when Make My Trip is taking the data, it is going to tell you that I need your consent because I am not going to book your ticket. I need to give it to somebody else. They'll have to take your consent. And it must be clearly disclosed and contractually controlled. TikTok, DPC, and here even the European Data Board was coming into the picture here. European Data Board is under Article 65 of the GDPR. If there are two countries of the European Union and there's an issue which is affecting both those countries or more than one country, then the European Data Board will come into the picture. Otherwise, they've got their independent data protection commissions in each country. So in TikTok, $345 million, 340 million euros was the fine, and there was a higher fine in some later orders. So what happened here? It was failure to protect children's data. Transparency was not there. This was in later decision, they even found transparency was not there. And there were concerns about transfers or remote access by the staff outside EU. And that is why it came into the picture that even the European Data Protection Board had to come into the picture. The root cause was lack of default privacy settings, inadequate child-focused protections, and opaque data transfers. Now remember, this, if it happens in India, there's a fine of up to 200 crores because there are separate obligations regarding children's data. So how it could have been avoided with default private settings should have been there, parental consent should have been there, verification should have been there, strict localization that only within the country, not outside that country, and guaranteed safeguards were not there in place. They should have been in place for any cross-border transfers. This is the same thing from a DPDP perspective. The health apps used by the minors must default to the highest privacy settings, and cross-border access to sensitive health data must have enforceable safeguards. In the Belgian hospital case, the cyber attacks revealed governance failures. What happened was that Belgian hospital suffered a cyber attack exposing sensitive patient data and was fined 200,000 euros by the regulator. The root cause was inadequate security safeguards, weak risk assessment was never done, poor access control, and there was lack of regular security testing. The one which I said, the pen testing or even other testing, regular security testing was not done. So lesson from DPDP, the breaches are going to be assessed, as I said, on your governance preparedness, not merely on your breach. Just because of the breach, you're not going to have a fine. They will see your entire governance preparedness. They will see your failure to implement reasonable safeguards. These can lead to penalties, even if the attack was external. By external, I mean an external, a cybersecurity threat or someone external as well. Still, if your internal documentation and your processes are robust, the fine will not be on a higher side. EasyJet 2020 customer data breach, approximately 9 million people are affected. Here, the credential stuffing and cyber attack exposed the emails and travel departments, even travel details, even in certain cases, the credit cards were exposed. The root cause was the credentials were compromised, the delays, and then there was a delay in the detection of the breach and delay in notification. Means you can imagine, in India perspective, it will be additional fines for those further reporting irregularities. Here, they did not have password hygiene. Anomaly detection for logins should have been there. They should have tokenized the payment data, and the customers should have been notified once the breach took place. So from a DPDP perspective, you must accelerate your breach detection and notification workflows, which are mandated by DPDP. Avoid storing raw payment data, which is not necessary. Ticketmaster in 2018-19, this was an incident where a payment page was compromised via a third-party chatbot vendor, which led to card data exposure of millions of people. The root cause was the third-party script was vulnerable, and there was a weak oversight of that. There was no embedded vendor code. It could have been avoided if you had restricted the third-party scripts on payment flows. You should have run supply chain audits, right? By insisting on strict contracts with the vendor. Security attestation from vendors. The vendor should give us attestation that yes, my systems are, and test them. Just don't rely on his mere attestation. So here, from a DPDP perspective, portals must treat embedded third-party code, whether for billing, scheduling, chatbots, as high risk, and therefore subject them to security and DPDP contractual controls. Because as I said, the penalty is not going to be coming directly in the data processor. It will come first on only on the data fiduciary. Now, when marketing tools leak health data, do you know what this means? In July 2025, a Swedish company, Aptoket AB, right? They were imposed a fine of Swedish kroner 37 million, which is approximately 3.2 million euros at that time's exchange rate. The regulator found that the pharmacy chain had used the Meta Pixel tracking tool on its website in a way that allowed sensitive personal data to be transmitted to Meta Facebook. So what happens is that it's a health platform, and you make an inquiry, right? You know that so-and-so illness, so-and-so ailment is there. Then you have something that, okay, which are the doctors? Immediately they'll come to know that, okay, something's to do with cancer. Therefore you search something on oncology. Then something, that data will go to Metaface. So they will know that, this person, then they will start giving you advertisements that here, this product, this doctor, this, that. So this is what happened in this case. They were not aware that there was a tracking tool on the website. The data information included the users interacting with the pharmacy and health-related pages. So as the pharma the website was dealing with the health products, right? So obviously it was an easy bakra for them, connect the tool and straight get all the data. So the regulator concluded that the transfer of such data to Meta occurred without an appropriate legal basis, and therefore this fine of 37 million Swedish krona. So please remember that here, user interactions on the website could reveal the medical conditions or the treatment needs, and therefore it was more serious. So what are the lessons from the Aptoket case? The first, healthcare websites are not ordinary websites. This makes digital marketing infrastructure legally more sensitive. Marketing scripts must be audited. Before deploying trackers, organizations must review them. What data is collected, where it is transmitted, whether third parties are going to receive the information, whether identifiers means to identify the individual, the PII, personal identifiable information, is it being shared? Without such audits, data leakage can occur silently. You'll not even know that it's happening. So the third-party vendor risk is real. Please remember, as I repeatedly am saying that please audit your data processor, the third-party vendor risks from global experience have been found to be real. The consent must be meaningful, and healthcare websites especially must ensure that consent mechanisms are transparent and specific, especially when sensitive data is being processed. This is a thing which I was talking about my own experience. This is what I'll tell you from, and this, I'm going to take a little more time on this for you. Qantas Airlines, there's no penalty yet because this is an ongoing investigation. What happened? Data breach involving about 5.7 million customers globally. The root cause is not yet confirmed as the investigation is ongoing. But then you'll tell me, why are you showing this as an example? The reason why I'm showing you the example is, just bear with me, I'll tell you why I'm showing you this as an example. It could have been avoided, very simple, ensure stricter access controls, should have had security safeguards in place, even by the third-party vendor. Now, how is third-party vendor, how do I know it? I'll tell you. What was the consequence? The penalties are not yet, but the Qantas board, they did a bonus cut of 15% for the CEO and the management team, including a pay cut of 250,000 Australian dollars for their CEO. And believe me, a class action lawsuit has been filed with the Office of the Australian Information Commissioner. This is an ongoing investigation to find whether Qantas met its obligations regarding customer data protection. What is the lesson from a DPDP perspective? Reasonable security safeguards as per Rule 6 and strong cybersecurity measures should be in place. Due diligence, because here again it's a third party involved, so due diligence and regular audit of vendors who would be contractually responsible. Now, I'll show you that how I came to know of this Qantas breach. As I must have told you before, that what is the responsibility of a data fiduciary once a breach takes place? Can anyone tell me? Once a data breach takes place, what is the responsibility of the data fiduciary? Inform whom? Inform DPDP board, DP board and the affected individual, right? The data principal. So here I was the affected individual. And please read this entire, how I was communicated, this entire thing will give you an example of how it is going to be expected under DPDP. So this I received from the CEO of the Qantas Airlines. Can you read it? I'm writing to inform you that we believe your personal information was accessed during the cyber incident we recently experienced. I want to personally apologize that this has happened and explain what we know and how we are supporting you. First, what happened? A cyber criminal targeted one of our airline call centers and gained access to a customer servicing platform. On Monday, we detected unusual activity on a third-party platform used by a Qantas airline contact center. We then took immediate steps and contained the system. We can confirm all Qantas systems remain secure. Please remember what I'm not saying the facts, but just remember the process because I'm going to ask questions after a few slides on this. Information that was accessed. Our initial investigation showed the compromised data may include names, email addresses, phone numbers, birth dates, and frequent flyer numbers. Importantly, your credit card details, financial information, passport details, and frequent flyer passwords were not accessed. Your Qantas points remain secure. What we are doing for you. Regular updates will be available on our dedicated web page. We've also established a dedicated support line for affected customers on so-and-so phone numbers, and with access to specialist identity protection advice and resources through this team. What you should do, we recommend remaining alert for unusual communications coming from Qantas, claiming to be from Qantas, being cautious of emails or calls asking for personal information or passwords. Remember, Qantas will never contact you requesting passwords, booking reference details, or this is the usual thing which comes from everyone. I want to reassure you that our Qantas frequent flyers, that there's no requirement to reset your passwords or PIN. If you have trouble accessing your account, then you reset your password by calling the Qantas frequent flyer service. Then regarding your travel, whatever is there is all normal. Then our commitment, we are taking this incident extremely seriously and working with the government agencies and independent cybersecurity experts. We are implementing additional security measures to strengthen system monitoring and protection of your information as part of our response. If we identify new important information as we continue to investigate and respond to this incident, we will share it with our customers. Again, we are deeply sorry this occurred, and our focus is doing on all we can support to you. Then I got an update after some weeks. Update on your data impacted. These were all emails which came to me. We are writing to provide you with an update following our previous email about the cyber incident on Monday, 30th June 2025. Additional data type identified. On our ongoing investigation has identified that your phone number details were accessed in addition to the data types we previously advised. What you should do, we recommend you remain vigilant for any unexpected contact by phone in addition to the email and text message precautions which were outlined in the previous communication. All customers continue to have access to the dedicated line, support line and all that, and take specialist identity protection advice and resources. I'm going to come regarding this after a few slides. I'm giving you time to absorb that what did Qantas tell us. So what is a personal data breach? It is unauthorized processing, unauthorized access, unauthorized sharing of data, destruction or loss of access to personal data, unauthorized alteration of data, accidental disclosure of data, ransomware encryption impacting availability. Such breach compromises the confidentiality, integrity, or even the availability of personal data, and this is data breach. Now let me give you an example. You are traveling in Ola or Uber or even the Kala Pila taxi, right? And you are having a file with you which contains confidential personal data of your client, right? You are supposed to do some work on it and then go and meet him in his office, okay? That file, you were going through, reading through it, all the pages and everything, and then suddenly you got a phone call, you put the file at the side, you reach the destination, that guy told you, itna paisa, you paid him and you got down, right? The car went, the taxi went, lost, correct? Is this a data breach under the DPDP Act? If not, why? If yes, why? I'm not coming to any conclusion because I want you to come to the conclusion. is this a personal data breach? It was the personal data of your client. You were supposed to do something on it and you lost it over there. It's an accidental breach. Correct. This data is not yet digital, so it does not come under the purview of the DPDP Act at all. It was a physical theft. There are other remedial measures for you. Go complain to the police, do whatever you want. But you can't go to the DPDP board and say that because that client person is my data fiduciary, so my data was lost. But that was your physical data which was lost by that file. It's not a digitized record. Then DPDP comes into play because it's digitized now. So it is unauthorized access to that data. You are not supposed to have that data. You did something which you are not supposed to do. You didn't have consent of the original person whose data it was. So it's definitely the DPDP provisions will apply. Who will be responsible? In this case, you've got a very classic question. Because the file was given to whom? To the data fiduciary, right? The data fiduciary, the employee did this. If I was in your place and if this had to happen, I would complain, take my recourse to the data principal, saying that you should have ensured that my physical data, but ultimately my physical data at some point of time was going to be digitized. So my source data should have been taken care of by your employee. So the data fiduciary will be responsible for sure. Of course, it's a theft, it's something else. All those other things will happen to that person midway who did that photo ganging and sharing. There'll be other laws which will be applicable to that theft and everything. Those actions will be taken. But for me as a data principal, I will hold the data fiduciary responsible. So why delayed or weak data reporting can trigger severe penalties? See, this reporting to the data, this data breach reporting has to be done without delay to the affected principal as well as to the data protection board. Without delay means as soon as practical, do it. You can't take time, you can't sit on it. All that हो गया, ठीक है, बोलना तो पड़ेगा, नहीं तो fine है 200 crores additional. And after this initial report, you have to give a detailed report within 72 hours. This is under the data protection DPDP Act, data protection to the data protection board. Within 72 hours, a detailed report has to be given. So first, because there are certain things which you may not have noticed on the first day, right? There are certain additional things which must have surfaced or resurfaced, which will have to be brought to the notice of both the data principal as well as the data protection board. So what should a compliant data breach notification typically include? That Qantas thing which came to me was a data breach notification, right? So what should it include? I read the entire thing with you. Tell me, what should it include? Okay, the first thing is what data was compromised. Then, what precautions they have taken. Okay, then, okay, what was the root cause? Okay, then, sorry, right, okay, right. So that means you had paid attention to my effort of showing you the data breach notification notice. So here it is. First, description of the nature of the breach, the categories and the volume of data affected, details of the vendor involvement, if any. Here there was a third-party vendor involved, right? There was a data call center or something, which they were travel center, whatever they were saying. Number of affected individuals, if you know how many were affected, the likely consequences of that breach, measures taken to mitigate harm, contact details of the responsible officer, corrective and preventive actions. The report must be factual, timely, and documented in detail. Inadequate or delayed reporting for sure increases the penalty exposure. Don't think that by not informing, किसी को समझेगा नहीं मालूम पड़ेगा बाद में तो fine is going to be, and then they notice there are two breaches, not one. The fine will be 200 plus 200 because both had to be notified. And then even the 250 crore wala breach is separate, lying on your, on your head. The tangti talwar, as we say. So organizations often believe that they are prepared for data breaches because they have an IT incident policy, right? But DPDP breach reporting is not just a technical exercise, let me tell you. It's a legal obligation with defined expectations, defined timelines, documentation standards are there, and the accountability is at a senior level, even at a board level. Here the CEO of the organization wrote to me, not the CISO or the Chief Data Officer. That you can imagine the seriousness which was there as per the Australian Information Commission, what was expected in the Australian data privacy law. Many breach response plans, if tested today, and we've seen it in organizations, would fail the regulatory scrutiny because such response plans, either they are IT-centric rather than being compliance-driven, they are unclear about regulatory reporting triggers. They have the incident reporting is there, but when to report, how to report is not there. The silent on the DPDP documentation requirements. They are unaware of certain obligations. Does anyone know what certain is? CERTIN is the Indian Computer Emergency Response Team. CERT in is for India, and CERT is Computer Emergency Response Team. That happens when there are cyber security incidents. Then your reporting to CERTIN comes into play. Your data breach response plan, they are somehow not aligned with the vendor notification clauses. They are lacking clear escalation to lead. There's an IT incident plan as you have, but you don't know how to escalate it within your organization to your leadership. So failure to detect or report a breach in time is not treated as a minor procedural issue anymore. It will be viewed as a governance failure. So when certain reporting is also required, under Indian cybersecurity regulations, certain reporting obligations are within 6 hours, and they apply to certain cyber incidents, including data breaches, ransomware, unauthorized access, system compromises. So DPDP and certain, the reporting obligations are different. Both have to be complied with. A cyber breach may require technical incident reporting to certain. Personal data breach reporting is to DPB. And the communication has to be of both to all the affected individuals. Failure to understand this dual reporting obligation is a serious compliance gap. Now the interesting question which comes is, you have a data breach and you later on come to know after 72 hours or within the 72 hours period that it was related to a cybersecurity incident, that there was a ransomware or there was some third party, from external thing, there was a phishing attack or whatever, and therefore there was a data leak. Now you informed the DPDP in time, but here the certain obligation is within 6 hours. So how will you address that? Anyone? So the certain obligation, the 6-hour meter starts when you become aware of the cybersecurity breach. So you first came to know of the breach, you reported immediately without delay, you reported within 72 hours to the DPDP, to the DPB board, but you realized during the process of investigation that it is a cyber incident. From there your 6-hour meter starts, your time, the clock starts ticking, and you have to inform the certain also. Clear? Yes? So delayed reporting triggers penalties. There was a British Airways was also fined under GDPR after failing to implement adequate safeguards, and for delayed breach management following a large-scale data exposure. Here, because of delay, their fine was even more. Marriott International breach also resulted in significant penalty due to delayed detection and delayed response. So the simple lesson is delay equals liability. Delayed reporting, more penalty. So let me quickly go to what happens in a startup. There's a data breach. It can happen because of cloud misconfiguration, sensitive data exposure, no encryption, no monitoring, delayed detection, no incident response plan. There's obviously exposure to the DP board. The common startup issue is there's focus more on growth and less on governance. And therefore the basic securities are found to be missing. We find that there is no DP or compliance role in startups. Vendor dependencies are high. Penalty may be existential. If penalty ek bada aa gaya, your startup ka, bach gaya. And investor trust is impacted. The investors who have invested in your startup, the trust is impacted. Let's go to large enterprise data breach. What happens there? Because the data is so huge and it's so widely across the organization that if there's a data request for deletion, and if you do not know where that person's data is sitting in your organization, or it may be sitting in a third-party vendor's data processor's system or server, you will not be able to delete that data. Legacy systems, as I told you in the Starwood Marriott merger acquisition, the legacy data which you are inheriting because of that amalgamation or merger, that can lead to a data breach. There are multiple databases, because you have databases in different countries, you've got different cloud servers, multiple databases are there. Repeated complaints are possible in large enterprises. Don't think that's a large enterprise. In fact, the scope or exposure is even more. So there could be repeated complaints. The regulatory escalation is definitely therefore going to be there. Audit failures are going to be there in large enterprises too. Because the larger the complexity, the bigger the issue. The data silos are common in big organizations because you have data sitting in one department, data sitting in another department, one person's data sitting here, also in another function. So the data silos are common. So therefore the rights fulfillment, the data principal rights, if a data request comes, how to fulfill the right within the timeline is difficult. Manual process will definitely fail here because the complaints will accumulate one after the other, and regular interventions will trigger at every breach, every complaint. Ultimately what will happen? The brand reputation and damage. You might say middle organizations say, chalega yaar, aa gaya paper mein chalo, baad mein public mind they'll forget. But larger organizations who are global organizations, MNCs and all, for them it is a big thing. Vendor breach, something which I have been repeatedly telling you during my talk today. Third party failure, data breach for sure. Data is shared externally. There are weak contracts which will expose you. You can't then hold his neck if your contracts are weak from this DPDP perspective. Delayed detection, because if it's the delay, the breach is at the vendor's end and you're not able to detect it in time, right? The DP board will still hold you responsible because he is your agent. You should have had processes in place to identify and understand when, if there's a data breach, how will his system trigger it and how his system will automatically inform it. So if there's a delay over there, the penalty is on your head. The breach is discovered late and the data fiduciary is held responsible. The cross-border risk is possible because if you have a vendor sitting outside the country and if the country falls into the negative list which is going to be notified, there's definitely going to be a cross-border risk. You need therefore strong vendor agreements and strong vendor governance and strong vendor monitoring. Now let me read this. This is another thing which affected me. How many of you all are using HDFC credit cards? Very good. And how many of you all have started or ever used the rewards which are there, the rewards which come with the cards? You've used it? Very nice. So you must have come, when you tried to do that, you must have come to this disclaimer. You may not have realized it, but because my eyes are trained in a different manner, so therefore I caught this and I said, and I had to, this happened just 2-3 days before, I immediately changed my slides and put this here to show you all. Let's read this disclaimer. By clicking proceed, you are acknowledging and agreeing to this disclaimer and the subsequent automatic redirection to a third-party website, that is the website of Reward 360, which you may proceed to use your transactions. For your transactions. This website is not owned, controlled, or endorsed by HDFC Bank Limited, its affiliates, subsidiaries, employees, officers, directors, personnel, or agents hereinafter referred to as HDFC Bank. HDFC Bank does not warrant the accuracy or completeness of the services, information, materials, tools, or reliability of any service, advice, opinion, statement, or information displayed or distributed through the website. Through the third party's website, that is. Furthermore, it is advised that you make your own inquiries and arrangements to verify, scan, and check the website for any viruses malicious codes or malware. HDFC Bank provides no warranties whatsoever in this regard. Upon agreeing, you understand and acknowledge that accessing, availing any service offered on the website or relying on any opinion, statement, or information presented on the website shall be at your sole risk. This information, the services available on the website is subject to change, revision, verification. Now tell me that this disclaimer, what are your views on this disclaimer? This is HDFC Bank, right? And it is keeping its site safe because it's a third-party website. So it's telling you transparently, okay, मैंने नहीं उसको. What are your views on this? Sorry? Who is not taking ownership? Okay. What else? Right, but why it is not proper? No, but why it is not proper from HDFC Bank's perspective? That you are saying they are raising their hands. So correct. And anyone else? Anything else? That is another very good point which you have, that when they gave you the card, they did not tell you that there are certain things which are going to be processed by our website, and they should have taken your consent at that time. I agree with that. To your point, gentlemen, what you're saying is also right. This is a vendor, it's a third-party processor of HDFC Bank, right? If this had to happen after 13th May 2027, HDFC Bank will definitely be hauled up for this, because the vendors will not, the data processor will not be penalized by DPDP. HDFC Bank, being the data fiduciary, is going to be penalized. Clear? Now, somebody of you can go and tell HDFC Bank, aisa advice hai karke. Okay. So all this goes finally to the boardroom. Then boardroom, what questions are you think might be asked, when a data breach takes place? What do you think? What kind of discussion will take place in the boardroom when a data breach occurs in the organization? Sorry? And what else? Yeah, and? Correct. And? First of all, क्या data breach हो गया वो तो पहला होना चाहिए ना. What was the data breach? How serious was it? So what type of data was impacted and how many users were impacted? The board would like to know. They will be very happy to see whether we can contain this incident in 24 hours. It's a big, high dream, but they will expect that. Was the data encrypted or masked? Has the regulator been informed in time? Right? That's the most important thing. You're all saying data breach ho gaya, but was DPDP informed? Was the affected principal informed? Is there a media exposure risk here? What is the financial impact? What is going to be? What are the highest penalties? The board would like to know. Because there are one breach, there can be multiple penalties. Who is accountable? The point which you had said, which you raised. What risk mitigation measures, you rightly had said, can be implemented? And what are the audit findings and corrective measures? So what are the final tips and takeaways? Treat DPDP as a board level risk, not just IT compliance. Build data visibility. Please, you should know where your data resides in your organization. Implement strong access control and monitoring. Establish vendor governance and contractual safeguards. Prepare a clear breach response plan. And maintain documentation, because when the proceedings will start before the board, DPDP board, this documentation is going to help you, and only that documentation will, I will not say save you from complete penalty, but it will at least help you to mitigate the level of penalty to a great extent. Conduct regular risk assessments and testing, not just in your organization, but even at your third-party vendors' locations. See, breaches are inevitable. Even if you are 100%, you say, yes, I'm so-and-so organization, the number one in the world, and I'm DPP ready, GDPR ready, HIPAA ready. Breach is inevitable. Kuch na kuch ho sakta hai. But the level of penalties, if the breach is in India, would depend on intent, whether reasonable security safeguards were in place, whether risk mitigation measures you took, whether the measures have been taken to prevent recurrence of the breach. That will decide how much should be the level of penalty which the board will decide. The board means the DP board will decide. The regulators will assess your preparedness, not just the breach, not just the incident. Again, repeatedly, how many times I must have said, one breach can trigger multiple penalties, so be very careful. Vendor risk is your liability under DPDP. When I'm saying your, means the liability of the data fiduciary. Data principal rights management is going to be a major enforcement focus after 13th May 2027. Governance failure is nothing but compliance failure. Prepared organizations will reduce both the impact and the penalties by embedding privacy by design. You should design your entire systems and structures in such a way that you will ensure that data privacy obligations and compliances will be taken into control. Your systems itself have been designed. So as we call it, privacy by design. That's all from my side. If there are any further questions, I'm happy to take them. Can you come back here? Okay, can you come here if you want? I don't know if there's any mic here.
So, for an example, once the data is gone outside of my organization, is there anything that I can do to purge that data or to ensure that no further damage happens from that?
Yeah, so your IT systems can have those things to see that the further leakage doesn't take place. You block the data. Those things, it depends on the level of the organization's maturity or the IT maturity which they have. But there would be technology measures which can be taken place so that further leakage is not there. They will try to restore it to the extent possible. But you cannot reverse it completely because the breach has happened.
Yes. So once the data that is gone out, nothing can be done about it.
It depends on the type of data. It depends on the organization. It depends on what IT controls and measures they have. I cannot tell you carte blanche, yes, that this will happen in every organization. It depends. Yeah.
Is any way the data principal will get any compensation under this act, or out of this 250 crores who will...
Super question.
What will happen?
I had deliberately avoided this in my presentation because I wanted somebody to ask me this question. Otherwise, I would have just, like walking from here, I would have given a passing remark on this. The Act, unfortunately, does not have any compensation provision as of now, as of date. Because the penalties which are going to be collected will go to the Consolidated Fund of India. It's written very clearly in the schedule. In the Information Technology Act and rules, there was a compensation under Section 43A to the person who was affected. Here it is not there. Now there was a recently, how these data, these WhatsApp groups, there are certain petitions which keep coming. One such petition did come to me also, please sign this petition. The petition being this only, that our data is getting affected, right? And you are going to get 250 crores. What about me, right? So you are right. But I cannot, standing here, can tell you that that it will happen or all. But as a citizen of India, I said yes, it should be, and I think better sense will prevail in some way because there's still time till 13 May 2027, right? Let's hopefully expect some amendment further or some rules, some amendment saying that yes, even affected data principal can get compensated. You can put, like conditions or relevant factors as to how much it should be, how it should be. That can be done, but some compensation should be there. You are right.
Thank you, sir. Thank you.
Yes, over there compensation is given, but in the India it is not there. But over there also, if you see, if you see any of the incidents, you'll always see these penalties up to 4% over there, up to 4% of the turnover or whatever is there. There is never any report which I have seen that this much compensation has been given to individuals. There may be other, like you go like here. If I would look at it this way, that you are a consumer, right? Data privacy law is there. Your data got affected. Because you are a consumer, you have a consumer grievance. Go to the consumer redressal forum and file separately over there. Just because this act does not mean that your right is extinguished. As a legal person, I think you can still try that. that,
I may approach the consumer court for
yeah,
that.
only to the limited. You can't discuss DPDP breach over there and try to bring that, see, my matter is here also, my matter is here also, nothing of that sort. Just simply that please compensate, that this kind of sensitive data was affected, how it consequently affected me, and you'll have to be able to quantify and justify the compensation you're requesting for. Yes? Can you on the mic, please?
Sir, as a data fiduciary, how will I prove that I have erased all the data on request of the data principal, and on behalf of, as a data principal, how I can be sure that they have erased my data?
So you're right, no? So your systems itself, your computer IT systems which are there will itself have to take care of this. That is what the law expects you, that if there's a request for erasure of data, it is not a simple request. It is not just from your servers, it is even from the servers of a vendor, someone who's assisting you in processing the data. The data might be sitting over there, not even in your organization. Now he might have he might have a sub-agent somewhere. It is a very complicated case. So you'll have to have evidence to prove once the complaint goes that because within the reasonable time he's not erased my data, the complaint goes to the Data Protection Board. It will be a hell of a problem for this company if it cannot evidentially prove that the data was erased. Yeah, it can, but it has to be tested. But you can complain. There's no process like that. You can. If your thing is satisfied, you find the complaint, you can withdraw the complaint. Anyway, now I've already crossed 15 minutes beyond, so it's 4 o'clock. So if there are any other questions, you can always offline. We can take them. I hope I did not bore you for a lot. Thank you very much.
Thank you, Dr. Laud. Dr. Laud will be around with us on the tea break, so we can continue our discussion there. There was a very interesting and extensive discussion that we have just had. I would request the audience to carry out a warm applause as a vote of thanks. I would also request the audience to assemble a little quickly because you're running a little late.